square feet? No, I was looking at this one, but I don't think it's built yet. So if you look at this address, it puts you right here. There's a house with a barn already. But I think their building, this is part of that extended drive. So they must be building something. This one here. Oh, so they want two structures? Yeah, I don't know. I was trying to figure that out because if you look at the layout, it's like not the house that's built there. So they're building another house. Yeah. Thanks. I got the first one. Oh, shoot, that's what I think I got to zoom into the call. Yeah, Carrie mentioned she's going to be in that office. Yes. Taking notes. Yeah, I saw that email. So yeah, you got it. She was here a little bit ago.
Yeah, she was outside. I think she had to like unlock the door. Like
locked me out.
Yeah, she's.
Oh, okay. It wasn't. So I don't see a house in here. I mean, a separate garage, do you? No. The picture does? No. That's what I'm thinking. This is hasn't been built yet. This is like that driveway. So go to this house to that side, but when you put the address in, it comes to the house that's right there. That says new construction. Yeah, that's what. Yeah.
Probably I don't know if she hasn't been here, so they're we have to try to get ahead of it and set it up here. So when they come and look and say,
Yeah, maybe if they were outside that. Maybe about 140 or something. Then you start getting into pretty big size. Now, would you rather see it sitting in the yard or would you rather it in the barn? I'm just jealous. I'd like a barn that big. Pretty sweet.
exactly, I thought the same thing. Why should, you're right. When an application comes in, it should be posted on the website. I said the same thing, so I tried to think the same way. Yeah. Well, look at
Carrie, do you need me to turn the Zoom audio on, or are you getting it from the other audio?
What? No, no. Steal this.
Okay. All right, so I think we're good with that. Carrie did, right? She was in the other room,
My dad was shipping corn one day, and you know, the tunnel was up there with the corn counter, they gave us the corn. It was one of their well, they went by with the glove and just tapped it, they called the glove and stuck his arm. And so, just, so, get up, terrible.
Yeah, what size?
My dad, he did that, I'll take it.
Well, we got a trailer for that.
And just, you know,
It's about 24 foot, it's about the biggest bedroom, 30 foot. You know, without the trailer.
Yeah, no, that's what he's got sitting in his yard. Awesome. Pretty sure tow company's got.
Yeah, we,
Makes sense.
the 20 footers are pretty common.
Yeah, yeah.
It's 7 o'clock, we'll call the meeting to order. Please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Approval of the agenda.
So moved.
Yeah, support.
Motioned and supported to approve the agenda. All in favor signify by saying aye.
Aye.
Agenda is approved. Approval of the minutes for March 11th, 2025 regular planning commission meeting.
I move we approve as presented. I didn't see any issues.
I had no other comments either. Support? All in favor signify by saying aye.
Aye.
Aye. Meeting minutes are approved. Call to the public. First, call to the public is for items that are on the agenda. And please keep the comments to 3 minutes. Hearing none. Move on to old business. Item number 1, utility. Oh,
This first. The public hearing.
yeah, should we?
That is.
Said 7. Yeah, that was, that's always been odd,
Yeah.
because it's old business, or because it's new business. But we can just have the public hearing and then we'll take action on it during.
Later.
Later, that's fine, we'll keep the agenda as is. So at this point, we will, or I'll accept a motion to close the regular meeting and move into the public hearing.
So moved.
Support.
Motion and supported to close the regular meeting and move into public hearing. All in favor signify by saying aye.
Aye.
Aye. Motion carries. So this is a public hearing. Opened. Reading of the public notice. This notice was published in the Tri-County Times on Sunday, March 23rd, 2025, in compliance with the Open Meetings Act. Notice is hereby given that the Tyrone Township Planning Commission will hold a public hearing on Tuesday, April 8th, 2025, beginning at 7 p.m. at the Tyrone Township Hall, 8420 Runyon Lake Road, Fenton, Michigan 48430. The purpose of the public hearing is to receive public comments regarding the following requests. A request by Richard and Rebecca Ellsworth for an increase in the permitted detached accessory building floor area up to a maximum of 1,200 square feet, which 1,200 square feet is requested, subject to compliance with the percent lot coverage, placement, and height standards in Article 20, Schedule of Regulations, and Section 21.02 G1 A through B of the zoning ordinance. The property is located at 6333 Shannon Glen Drive, Fenton, Michigan 48430, parcel ID 4704-32-100017, zone R1, single family residential. A request by Donna Miller for an increase in the permitted detached accessory building floor area up to a maximum of 1,200 square feet, which 1,200 square feet is requested, subject to compliance with the percent lot coverage, placement, and height standards in Article 20, Schedule of Regulations, and Section 21.02.G.1 A through B of the zoning ordinance. The property is located at 10254 Royce Way, Fenton, Michigan 48430, parcel ID 4704-04-101-004, zone R1, single family residential. Additional information is available at the Tyrone Township Planning and Zoning Department, 8420 Runyon Lake Road, Monday through Thursday, 9 a.m. to 5 p.m. Individuals with disabilities requiring auxiliary aids or services should contact Tyrone Township Clerk at 810-629-8631 at least 7 days prior to the meeting. Moving to review of the application.
Quick, let the record show Zach Tucker's present.
Thank you.
Yep.
Kevin, can you turn this?
Oh,
I think he's right by you. I tried
oh,
with this.
sorry about that. I plugged it in.
Yeah, no, yeah.
Okay, so,
Yeah, it's good. Is it good? I don't know how to use technology.
so at this time, while they try to get the TV going to show some of these exhibits, the first one on the public notice was Richard and Rebecca Ellsworth. If you would like to go over your, is the applicant here?
Yeah.
Yes. If you would just like to give a summary, you can come up here so the microphone can pick you up and you can give a summary of what you're requesting. Yeah, just do a tap.
Yep.
Sounds like it's on.
Sounds like it's on. Well, we have a 6-acre lot, and we're gonna build a 3,400 square foot house, and we wanted to build a bigger detached barn garage for storage of equipment, that kind of thing. And it'll be set back quite far from the road. And I know you guys have the requirements that you need to apply for this 1,200 square feet. Do you guys have topographics?
Yeah, I can move, I got everything that you provided, so I can,
Okay.
pull it up on the screen,
The detached garage will have identical siding and everything as the home.
yeah, looks nice. So the home is not built,
The home is not built.
nothing's built.
That's
Big
why
lot.
we're waiting to start, so
Yep,
if we could do it all together, it's a little bit more convenient.
Quite a big lot for R1.
Yes, it is. It's not big enough to be agricultural, but it's,
It's some unique lots back there. We've dealt with some other applications for that road and such. So one question I have,
We should probably get the name, just for the record. Just for the record.
My name?
Yeah.
my name's Richard Ellsworth,
Okay.
the applicant.
applicant.
And the address?
It's 6333? Yeah.
Okay. I just want to make sure.
I think that's more important for the public
Right.
comments too.
Right,
But
right.
We haven't,
I just want to make
we
sure it's on the
haven't-
record.
Yeah, Shannon Glen Drive.
Sorry.
Off the top of your head, what are the setbacks for R1?
Is it 20 or 50?
um,
I think it's.
the rear yard setback is, one's 10 and one's 15, right?
Yeah.
It's within the setbacks.
All of it's within the setbacks. He's just asking for. a little
This
bit
is
more
just for size. So
Yeah, this is for size.
that's the question that I had, is in the drawing, it says, I guess, to go over what the planning commission's duties here are, they may approve an increase in the permitted building floor up to, this is for the detached accessory structure, up to a maximum of 1,200 square feet from the 800 that's permitted. But, so your barn that you're proposing is 34 by 52?
Well, we withdrew that because of
Okay.
your restrictions.
Okay,
And then we just said we're not gonna put the barn up right now. And then got word that there's a possibility this township is gonna increase the size of accessory buildings in the
Well-
near future, possibly. Again,
Well,
not
what-
that it's a done deal, I understand.
and that is a separate issue, but since
Yes.
you brought it up, what we have discussed is, so within this zoning district, 800 is permitted, meaning you just go to the building department or whatever, and you're permitted for 800. But you can go up to 1,200 by coming to the planning commission. And we've discussed potentially just having that be permitted for 1,200, right? So, which, that is all that's in the future, if we did do that, and, who knows exactly what zoning districts that would apply for, but,
So the initial one that we drew out, the barn was 32 by 50, which is about 1,700 and some square feet. And so we're applying for the 1,200, hopefully that we get it. And then next month, we're supposed to come back to the zoning board to see if we can apply for the full size.
that's something I didn't know, but I think it's outside of the,
Yeah,
it's outside of this.
Yeah, it's not the planning commissions, say it's zoning board.
So you're requesting up to 1,200 square feet?
For you guys, we're requesting 1,200, yes.
I mean, I went over today, kind of looking all over. I mean,
Speak up just so everyone.
no, I just was saying I went over in that area, right?
I didn't go to the site, but I did go to the site multiple times on other applications.
Yeah.
I'm well aware of the site. It's heavily wooded.
Yeah.
It's very unique for R1, which is 6+ acres or 6 acres. I see, no issues with 1,200 square feet accessory structure. But
I didn't see any issues, just, again, like I just saw it from the road.
So I think we just, go ahead, Rich. Any other questions for the applicant while he's up here? And we'll review this application, and then we'll review the next one, and then have all the public comments together. Is that correct, Rich?
That makes sense.
Okay. So, anything further from you, or any other further questions from planning commissioners?
I just wanted to follow up, looking through the factors, and you touched on this already. You mentioned use for storage. Is there any plans to do anything loud or bright lights or anything like that out there?
No,
Okay.
we came from 10 acres and we had a 70 by 35 barn. And so I have a tractor, a gator, stuff to lawnmower, a lawn vacuum, just a lot of stuff to take care of the place.
That makes sense. Thank you.
And hopefully people want you to take care of your place.
It's just about downsizing at this point from,
Pardon?
you said a 70 by 30?
Where we
Yeah.
sold that home.
Oh, okay.
And so now we have stuff in storage right now.
Yeah. Well, I'm thinking, because this is literally half the size-ish.
Yeah. We had an indoor basketball court, so.
My man.
And very good point, Zach. Within the zoning ordinance, things that we can look at, and from what I looked at, I don't think those are, but potential for generation of nuisance factors such as traffic, parking, noise, vibration, glare, odors, fumes, electrical interference, or hazards. I don't see any of those being an issue. Or the orientation of the doors, drainage, I would assume that you're having this barn, from what I saw, those drawings are pretty nice. Someone's gonna review the drainage.
Yeah, it's up
Since
on
it's a
a
larger
hill.
structure then, and you can see the contours here, it's got quite some slope to it.
Yeah, it drops off and the home will be a walkout because of the drop off. So everything drains down.
Any other questions for the applicant? Thank you. So still on reviewing of the applications, we'll make that plural, and we'll now review the other application within this public hearing, a request by Donna Miller. Hello.
Can we get your address?
Yeah,
It's for the record.
thank you, Mario.
No, that's okay. Oh, thank you.
Oh, state.
Yes, that's the state.
Yeah, can you just state your name and address?
I'm sorry, what? Oh, state my address?
Name and address.
Donna Miller, Rick Klein, my husband, 10254 Royce Way, in Peisner Acres. It's a
Thank you.
corner lot, and he's gonna retire for long, so we have a pontoon boat, side-by-side, and a Harley trike, so we want something that looks nice to store toys. So we're requesting the 1,200 square feet, and I think we do a map for you too.
Yep, oh yeah, I'll
And
pull
he's got
that
a
one up.
picture of what it'll look like. We've talked to our immediate neighbors, and they are okay with that. They wish they were getting one.
Okay,
My lot's kind of a deep lot.
here's the
Yep.
map.
Yep.
Driveway, and then the new structure would be in back, right there. Respecting within the, 15 feet, and
We have the setback for the side lot and the lot behind us, as well as the easement from the road. We've respected all of the easement requirements. In addition, we put in an extra 5 feet on each one of the easements to just give them a little more room. The 800 square foot building isn't going to be big enough to handle the pontoon boat and the camper. That's why we requested the 1,200. Now it's not so much as a pole barn if I can,
Got a picture of,
get a picture of,
Yeah.
it's gonna be more of a, it's gonna be a garage.
it'll be
That's-
different colors that
The
match our
color's
house.
gonna match the house.
Because it goes right up to there.
Metal, with the two-tone,
Yes, it's gonna match our house is brown.
Overhang?
Cream,
Yep.
yeah.
very nice.
So it's not a pole barn structure per se.
And that's to replace,
We're not replacing anything.
what about
No,
that?
we're gonna get rid of it.
Okay, okay.
It's like a little.
Yeah,
Yeah,
it looks like a
that's
little,
not-
that's-
lawn building.
yeah, it looks
Yeah.
like a little lawn shed, yep.
Does anybody wanna see this?
So I did drive by there,
Did ya?
and
Okay.
I saw, you know, you got the pontoon boat side
Yeah.
by side, and it,
A shed.
it seems to be, from what Ross has said in the past, I don't work in the zoning department, but what Ross has indicated before is that, you know, one of the number one complaint in the township is people storing stuff outside, so, you know, I think, putting it inside a building is good. One question I had is, there seems to be a berm on the corner, the side road Pressler. So like, where are you gonna, you're not gonna have a driveway, right?
No, we're gonna access it from the side of, just to the side of our access driveway and just go right down to the building.
Okay.
So we're not going over
Over the
the
drain field?
berm.
Yeah.
No,
Or the
he's
side.
on this side. He's got 18 feet to the house.
Yeah, over on the other side.
The Nora Drive.
The other side.
Over here, he says.
Oh, you're gonna access it over here?
Yep.
No.
On
No.
the
Well,
north
well,
side,
or
to
down
the
the-
south side.
Yeah, because there's a berm, like right about where this utility easement is.
Yeah,
there.
no,
There's
there's,
quite a berm,
Yeah, we're coming right down the other side of the driveway there.
but you're not gonna have another driveway.
No,
No.
It's just, you're gonna, through the grass, drive it through the grass, and
yeah,
just-
just store the buildings for the
maybe like
winter
a
and
little
that's it.
driveway approach or something. And then-
Right,
Just storage, no electrical, just.
no.
Yeah. Let's go through.
What is the height of the building?
It's 10-foot walls, 14-foot peak.
That was the only drawing there. And thank you for having that stake too. I drove out there and you could see right where the
Yeah,
building
yeah.
is. Any other planning commission discussion or questions for the applicant?
I don't know, it's my only question, how he's gonna access.
I'm good.
Thank you.
Okay, well, thank you.
very much.
So that concludes review of the application. We'll move to receiving public comments. So these public comments are only for the, for items on the public hearing agenda. And please state your name and address for the record. Hearing none, we'll close public comments and move to planning commission and planner comments. I think we kind of covered us, and I forgot to include our planner, Mario, here. So any comments that you have on these?
No, we didn't have an opportunity to review it, but you have pointed out that there are certain criteria within the zoning ordinance that you review. And you've been discussing those, so I would just make a recommendation that any approval you grant, we consider it of the required approval criteria, which you've talked about, so.
Oh, John, I do have one question. The first applicant mentioned something about maybe increasing that, and you said the up to 1,200 square feet. Today, it's a sliding window, right? It's either at 800, you don't have to come to the planning commission. If you want up to 1,200, which gives you a window, if it goes up to 1,200, just as a consideration, is the window going to slide as well? And then it would be,
Oh,
you
but
know,
I mean,
1,600 for the.
I don't think so. I think
Okay.
that would be the intent, but that would be
Yeah.
up to the planning commission whenever if we ever decide to move to that. I
Yeah,
mean,
yeah,
We
okay.
do about, I don't know, what do you say, Rich, about 4 of these a year maybe?
Probably.
You know, and
yeah.
we look at these certain things, and they're not bad to look at, you know, because it could, you know, if maybe some of these were, kind of come into play.
Sure.
But, you know, the difference in the 400 and 1,200 might not be the make or break it on these, you know?
Right, yeah, all right.
But I don't think the intent was to say, well, now you can have 1,200, but go up to 1,600 with approval. I think the intention of revising the zoning ordinance would be so we don't
Yeah.
have to do that at all.
4-0.
Yeah, exactly, yep.
Thank you.
Increase. Okay, we'll, close.
Make a motion, we close the public hearing.
Support.
Motion and supported to close the public hearing. All in favor signify by saying aye.
Aye.
Public hearing is closed. Moving on to, so we didn't need to go back to we're still in this, back to the regular meeting, right?
Yeah.
All right, so back to old business, item number 1, utility scale solar, wind, and battery storage overlay zoning district map. Just a quick brief summary, we've been working on revising the overlay map over the last 2 or 3 months, I'd say, number of meetings. At the request of relooking at it, from the board requests us to look at it. We got comments from the Livingston County that we've taken into consideration, and also guidance from our special counsel. And we've worked, I'll pull this up, sorry about that. We've worked to develop some draft overlay maps, and McKenna has assisted us with those. And then the last meeting, which was a workshop, we really didn't have any comments, and I think we're probably ready to move on to schedule a public hearing for this. So I guess I'll just put it open for McKenna, if you guys have anything addition that I left out.
No, just, we don't have any other further comments at this time. We're ready to make the proposed changes if there's further consideration from the planning commissioner or board, but I believe the maps represent what you want to move forward with regard to this issue.
Yeah, and I think the maps look good. I like the total acres in there and the acres of each parcel that we're proposing. This overlay map overlaid on the different other maps, utility map, zoning map, existing and future land use map. So good job on those. Any planning commissioner comments on this item? So I think if we all agree, I think we're ready to schedule the public hearing.
Yeah, no,
Yeah,
I feel confident, yeah.
Well, I mean, that's our next step, right?
I do believe so, yes.
Okay, so I don't think we need to officially take action on that, but I think we should, to schedule the public hearing. I don't know if it's exactly a decision that we need to make, but might as well.
Yeah, I'm not sure that we need to vote on it.
I don't know if we can.
No, but I agree.
No.
It's consensus.
Just
right?
consensus,
Yes,
yeah.
Unless we have some viable reason not to.
Yeah. So I think we'll go ahead and notify Ross to schedule the public hearing. And hopefully, you or Gage will hopefully attend that. Any other discussion on this item? Hearing none, moving on to old business, item number 2, Michigan Medical Marijuana Act caregiver regulations. You can go ahead on this one.
So within your packet, you have from us the original proposed draft of the zoning ordinance section of the Township minor changes to that text, mainly based just on a couple of typos we had in the beginning. Mainly because I felt that during our conversation at the workshop, the more your primary issues raised would be addressed with the regulatory ordinance. If you recall, our recommended approach in order to ensure that any medical marijuana caregiver that grows marijuana is in the right location is first to amend your zoning ordinance to make it more streamlined, make it more focused on zoning issues, and then the township adopt a separate regulatory and licensing ordinance that will have the ability to make sure that the operations of these caregivers is governed under the police powers of the township, and also so that they would actually be required to come in to renew that license at a minimum on an annual basis. So, with that in mind, I have prepared a draft, first draft of a regulatory licensing ordinance in your packets. And so, to go over that briefly, the intent, once again, is to make sure that any caregiver understands that they have to obtain a license from the township. And one aspect of this that I think is important is that you do have a precedence for this from some other, very few, but the township board has the authority with some other ordinances to grant licenses. So this process is set up in a similar fashion, where the town, anybody that wants to receive a license will have to go through the application process. Right now, we list it with the clerk, because that's usually your initial contact, but if you wanted to change that person to the development director, zoning administrator, that sort of thing, you can change that. But they would be required to prepare an application, understanding all the requirements, and then they would have to submit all the required documents, and then they would be go in front of the township board to receive a license in terms of compliance with those approval standards. So this is an enabling ordinance. First step goes over definitions. These definitions in section 4, beginning of page 1, are the same definitions as in the zoning ordinance. The intent is to make sure that we're being consistent. But then as a regulatory ordinance, you have to be a little bit more specific. So, we have a section that's where it explicitly states what's prohibited on a site. Stating that a primary caregiver cannot conduct anything under the Michigan Medical Marijuana Act or the MMMA without first obtaining a permit from the township. And we use, forgive me, I might use the terms permit and license interchangeably. We have that set up in there. It's just sometimes they call it a license, sometimes it's a permit. But in either case, when it comes to this permit, then ordinance specifically states that a person must have this permit in order to carry out their operations of growing marijuana for their registered patient that's under their specific care through the state. And then section 7 goes into permit requirements. And we kept these generally straightforward in terms of just making sure that everyone is making sure that any caregiver that operates in compliance both with the state law and with the zoning ordinance, and that's the key to this. By having this regulatory ordinance and making them comply with the zoning ordinance, then that requires them to then be located in the right district. So if any other caregiver is in a district other than the districts you prefer, then they cannot receive a license and they can no longer operate. So that's the intent of this. It basically ensures that full compliance with the zoning aspect of the proper district. So as I mentioned, there were some other aspects of the operations that I think you were concerned with. That you might want, that if you don't see in this ordinance, this would be the place to put it in, the regulatory ordinance. Because this is more intended to govern the operations and how a caregiver goes about their day-to-day business and activity, whereas the zoning ordinance is really about the facility and the location, making sure that it's in the correct zone, and that any site is developed to specific standards of the township. So the permit requirements are listed in section 7, namely, they have to comply with state law. They have to obtain any other necessary permits, such as a building permit, if they construct something new. That they can only conduct activities granted under the license. And then in terms of, one thing aspect I left in there because it was something that was, can be a choice by you on section 7, paragraph E, I did leave language that says, shall only display signs on the exterior or interior of the property that are in compliance with state sign regulations. Some communities don't want them to these facilities to be identified. So they sometimes say that they're not very restricted. Do you believe that's something that you could do under the licensing ordinance? As I mentioned during the workshop, we will have to make sure that the township attorney reviews this to ensure that everything is within the police powers of the township.
So that's,
And yes, please, at any time.
So in the zoning ordinance, J, signage, we say a primary caregiver operation shall not have any signage.
Right, yeah, that's right.
So I think, and we had that from a previous one, and I don't think, in my opinion, that we want signage. I would say reword the regulatory, say shall not have signage.
consistent, right? Got to.
Yeah, and please, as I'm going along, please feel free to just interrupt me.
Mario, on H, did we get down to, I think I heard that it'd be handled through the clerk. H, subletters or subnumbers 4 and 5, is it possible to put a notification time period in there? Would that be helpful? It just says, shall notify the clerk when a primary caregiver is newly connected, but doesn't give any time frame like 10 or 30 days or within 30 days. I'm not sure if that would be helpful here in this instance or if there's feedback from the other commissioners that might.
No, I think that would be very good.
I think that's a good idea.
That's definitely something to be added.
7 days or something,
7, 10.
something like that, yeah.
Yeah, it could be.
I'm okay with either. But it does sound like a good idea to add. What were we going to say, 10 days?
Yeah,
10
10
days.
reasonable.
Okay. So those are the requirements that that they must abide by, and then section 8 just goes over the application and review process. So again, this is some details of the information they must provide. I included some things that actually were included in the ordinance already for other uses, and so that's why I kept giving you things like computerized criminal history, any kind of letters of incorporation if they are operating in an LLC, about any employees they might have. But actually, that probably goes to one thing that I was looking into. Whether you want they even operate under an employee, because typically it's just one caregiver that provides that does all the activities for each individual 5 patients. So just catching myself there. This way, would we want to make sure that they do not have any employees? Does it matter in terms of, or maybe they need one to have, if they have 5 patients and 1 person? I don't have any experience with these individuals that have operated this way, so I don't know. As far as I know, they always operate on their own, but that's just close.
I think we need to keep it as strict as possible, right? And it should be to whoever's licensed to do the care. That's my thought. And-
Yeah, I just,
but I don't know.
I would lean towards not allowing delegation to employees. I mean,
Yeah,
the only reason you could want employees there is if they were providing security or, something like that could be favorable.
I think the other applicants that we've had at times did want employees and at specific times of like harvesting their crops or something, but as long as we think it's, you know, legally, I'd say reasonable to restrict it to no employees, and I would say none, in my opinion, but
Yeah.
I don't want that, you know, someone to say that's not reasonable, you know, but,
Are you saying full-time employees, or are you talking like just when they harvest, I mean, how are you gonna ban that, or how are we gonna stop that? You got harvest and.
well,
you
but
just
also
have-
what we don't want is, okay, it's growing for 2 months, and then when it's time to harvest, there's 20 cars that pull in the driveway, and it, you know what I mean, they're in and out, they're bringing friends, you know what I mean?
Yeah.
So I don't know, I mean, I'm okay with saying no employees, if that's,
Yeah. I'm all
I
right
don't
with
know,
that.
what everyone else thinks.
That's my thought.
You know, I mean, it's pretty restrictive, but if that'll fly legally, I would think that,
I wouldn't think that would apply.
but hopefully it doesn't. You mean the number of employees, or?
Well, you're telling somebody they can have a business, but they
Right.
can't have an employee.
Yeah,
I don't know if it would fly.
Oh, that's legally, I don't know, but we're not saying this is a business. This is a caregiver operation. I know, it could be business, you would think, right? Because they can charge the patients money. But I don't think we want to make this like a business, you know?
Well, the only other concern I would have is that the law does allow the caregiver themselves to also be requiring care. And if that's the case, then because they might be ill, physically, you know, they may not be able to do the work of harvesting or maintaining or other things. You know, you're putting a big burden on the caregiver in the case that, because they are allowed to also be
I think it would be best to get an attorney involved
Right.
with this.
Well, and also.
Because I'm looking
Yeah.
at the MMA right now, and I see the words employee being used in several different
Yeah.
spots, and which makes me think that, I mean, I'm just reading it in context here, it makes me think that, hey, you know, that they can have employees too. I really think that we need to get
Well, I would,
for a lot of these questions that we're having.
so this ordinance
my
right
2 cents.
here is going hand in hand with our zoning ordinance. So we're working on it within the planning commission. But
Right.
this isn't one that we even recommend for approval. I guess we can always recommend.
Right.
But, you know, this one is really up to the board, you know, and hopefully have an attorney review once we get it to a point where we want, or maybe we can even ask for like, hey,
Well, I was
review
kinda
what we
thinking-
have now.
Well, that's the thing, I was thinking,
Yeah.
like, you know, how we had it with Mr. Fisher for EI, you know, he was kind of like there to kind of guide us along. I don't know
Yeah.
your thoughts on it, that was just mine.
I think if we're gonna do
Listening.
that, I think what we wanna do is make a list of things, you know, because
Absolutely.
this
No,
is
we have
something we work on for over a number of meetings.
Yeah.
And not, you know, and then maybe get our legal questions, bring in the attorney, and then go over that.
So the thing is, if you do that, then you're gonna have your questions and then a whole lot more questions after you've listened to the attorney. That's
We might.
I was trying to
So
avoid that.
We might not
like-
we might wanna have an attorney review
Review
prior
first.
to,
Yeah.
you know, recommending approval.
Oh, yeah, so no, my recommendation
that's
would
it.
definitely be,
Yeah.
Yeah, that's-
is to
So-
make sure they get the attorney involved. So I think working with Ross, I can understand, we can figure out when
Yeah.
best time for them to conduct an initial review, and then
Yeah,
make
I think
their
that would be good.
recommendations and changes, and then you can react to those and then have questions based on the attorney's comments. Because the attorney's comments will probably guide you towards your other questions as to how restricted you can be, what issues you can or cannot address. So I think getting that initial review will be very helpful. And then you can work on that, on your questions for them so that we make the changes. Because we want to get to a point so that, and we'll work with Ross to see at what point that the board will want to take over on this. Because we do have the moratorium is lifted in June. So whether they extend that moratorium or they want to try and keep that as our target. they're putting things on the boat. But I wanted to at least get this in front of you tonight so you can see how it's structured, and how it usually works out. It's it's different than what you normally look at from the zoning.
I agree, you know, this is,
One question,
Yeah.
you're saying we would do this as a license thing by the township, but isn't the special land use permit in effect the same thing?
Well, that's another
This is
thing.
currently under special land use, so.
Well, right, so that's another thing that I would like to discuss with the attorney when it comes to that, because we discussed that special land use, there's two things of thought on it. Some of them are that once you grant a special land use, it runs with land in perpetuity. The only way you can remove it is by having it, going through a public hearing and having the planning commission and then even sometimes the township board, removing that special land use. And then the other aspect is the special land use is granted, but if a person violates any condition of approval, then that automatically nulls and void their approval, because they're no longer operating in faith. Now there's ways they have to have given sometimes ability to make the corrections and all that. But in any case, in either of those two trains of thought, once again, the idea is that from a zoning aspect of it, they're granted a zoning approval for the location and for the improvements on the land for that particular type of use. The second part of this is the regulatory ordinance, where we would issue a license. It's similar to typically actually things like pawnbrokers. They have to get a license. But they might get a special land use first, then they have to get a license. Restaurants, if they're going to serve liquor, they'll come in and get their approvals locally for a zoning approval. Some communities do require special land use approval for a restaurant, and then they separately have to go get another permit or license for how they operate for their liquor. So this is when you operate in a similar situation. One, you would be granting special land use right now for the actual zone, the location and the improvements. And then they would also have to go through this process to obtain a license from the township.
But, yeah, currently they have to get license from the state.
Right, and
And then the special land use from us, and we can place conditions. My concern is if we make a regulatory licensing ordinance and they meet all that, then are they obligated to comply with the special land use if they're
Yes.
meeting the license requirement?
That's a key to this whole strategy, is that like they have their
Just making
special
sure.
land use, and then they typically think that it goes with them in perpetuity and they can just operate in any way. And we have to hang our hat on other ordinances that are operational. This way, they're granted, they have to obtain a license, they have to operate, and if they violate anything, then that license can be revoked, and then they can no longer operate. So the license is intended, just like any license, to make sure that a person, when they're conducting an operation, are in full compliance with everything that is applicable to that particular activity.
Well, and the license would be non-transferable too, right? So, I mean, that way you don't have to worry about somebody trying to,
Yeah.
step into the shoes of somebody who's already.
No, and I
yeah,
think,
like someone that we thought was operating very nicely, and they sell their property, which goes with the special land use, and then someone else comes in and is not operating it appropriately. And if they violated the special land use, you could revoke that, but this might be an easier way to hold them accountable.
Yeah, from what I understand, the benefit of this too is that you can start writing them tickets for a license, you can pull their license, and then, yes, so that's another key.
is there any concern if we're only requiring licensing for one special land use and not the other 20
You already,
permitted ones? Yeah.
So I'm not an attorney, but to the best of my knowledge, you can choose which use does require a license, because you do already require them, for example, for adult businesses, they actually call them adult cabaret right now. You have an ordinance for that.
I don't
It's
think
an
we got
old
any
school
of
one.
those.
Yeah, it's an old school one, but it's another requirement.
I was gonna ask you that, because you mentioned earlier that we're not setting a precedence, because
Yeah.
there's already licenses. I was thinking, well, we got dog licenses or something, but I wasn't thinking about the other one you mentioned.
Hey, Mario, on denial of license on 8 F. It says, number one, the applicant is in substantial non-compliance with the rules. Is there any motivation to define substantial a little bit more, or is a recommendation to keep it broader in terms? It just struck me that substantial could mean a pretty broad aspect of different things. That's just,
Right, and that's a good point. I mean, maybe you should say something like the applicant is in violation of one or more rule or something like that.
I don't know what the right
You
number
could
is,
even
but
just
that's what I
strike
was thinking, just a
substantial.
little bit more
Yeah.
definition to it.
Yeah, just remove
Yeah, just remove
substantial.
substantial. Yep.
You just get a substantial, say the applicant is in non-compliance.
Yeah,
That's a good
non-compliance.
point.
Yeah.
Yeah.
And then, I'm sorry, number 10, section 10, since we were mentioning transfer of license, this statement does not indicate that the transfer of license is prohibited for the same location. It says for other locations, transfer to another business location or represented as pertaining to any other business location, but it doesn't specify that location where it was first granted. So if we could at least include this location and any other,
Yeah.
that would be helpful for that one. Unless there's something I missed.
No, that's good. That's a good catch too.
I had a couple of items as far as the application process is concerned. Now, some of these, I think, kind of overlap between the two ordinances. Might be better to put them somewhere else, but, we were talking about the concept of essentially the nuisance items, the smell, the light would, and I could see, as long as we're not overstepping, why we would want that to be something. They have to submit a plan for the lighting, a plan for security, a plan for smell abatement, in the process of the licensing. That would give the board the opportunity to, make sure that they're not giving a license to someone who's gonna violate that stuff too. So, and we can put the burden of that, the testing and the preparation of that on the applicant, I would think, under the licensing ordinance, and so.
Right, no, and that's another good aspect where, once again, since I'm not an attorney, I'm not sure, but I believe by then putting those items under the regulatory ordinance, it makes it a little easier for them to take action on them and also hold them to those, because, like I said, I don't know if that, it's already in, like you said, it's already in the zoning ordinance, but maybe it's like a whole thing. Sometimes I refer to it as like a belt and suspender situation. You might as well just have both in both places. So yeah, I will add a note there to that.
And this is kind of off the wall relative to that last comment, but I don't know if we have a comprehensive fee schedule. Do we have a comprehensive fee schedule?
But they said it would enact a regulatory ordinance to set the fee.
Oh, okay.
So
There's just a defined term in.
But in under section 8B, the required fee, is the application shall be accompanied by a non-refundable application fee to be established by resolution.
Okay.
So that if we get enacted, then the board will need to pass a resolution to set the fees.
So they would set the fees. Okay, that makes sense.
Typically, you review your fees annually, just to set them. I'm not sure what you normally do, but this is one way, also just little trick, not trick, but just an approach. You don't put your fee into the ordinance, because that's why sometimes, you get the old school ordinances where somebody has a license for $10.
Right.
Yeah, okay.
Right.
And it doesn't cover the cost of the township at all, so.
Right.
So, yes, so those are great suggestions, I think, those notes, and then really, the rest of the ordinance is, lays out the process for, once again, revocation of the permit. I do have something in here about letting them, to let them know that they have violated, giving them notice. And then the other remaining sections are your standard sections to include for adoption of a ordinance in terms of severability, savings clauses, and that. So, I will definitely make these changes, and I will definitely work with Ross on working with introducing this to the township attorney to get their initial changes or suggestions or something?
I thought the licensing was a good start. I just had one comment on the zoning one. If, it's just I noticed in reading letter F, number 4, around the school and childcare setbacks. I had made a late comment in our last meeting about bus stops. And so I didn't know if there was a reason or if they're included somewhere in one of these other laws that are mentioned, or if we need to call that out for the kids.
I did put it in there because I had a note that would be one of the first questions I asked the attorney.
Oh, okay,
To
thank
see
you.
if that's even
Okay.
possible. Because Ross made the point that, sometimes bus stops change. So
Sure.
I'm not sure if, what tools are available to us to include that. Like, I don't know, like, if there's some aspect to do. But yeah, that's definitely one of the things we'll check on, to see if that can be included as well.
Thanks.
What, since this has the regulatory ordinance part, I guess, when we send it to, when we have I'd say preliminary attorney review, should we have the board, Chris, do you think we should have the board look at this? I mean, we're adding a whole new licensing. I mean, I don't see any reason why it'd be that big of a deal, but, should the board look at this, or are we just gonna wait to move it all the way up to the board, they can make changes then?
No, I think it's a good idea. I mean, you can either have the board look at it preliminarily.
That's kind of what I was thinking, only because it does tie to the zoning.
Yeah.
So I don't know if, like, say we move it all the way up, the attorney reviews it, we're good with it.
That's right.
We have a public hearing for the zoning, recommended to the board, and then they want to come all the way, No, we don't want the regulatory report, we don't want the license, we don't have the staff for it. And that's not something really that the planning commission is kind of determining, so I just thought maybe like a preliminary review, it's just my thought,
Absolutely.
It could be good for the attorney cost perspective too, because I mean, the closer we get it to final form before it goes to the attorney, the less expensive it's gonna be in terms of legal side.
I mean, and I don't think this is like a big obligation to the township itself, but
No.
that's kind of up to the board to determine.
Well,
I don't want to be establishing this whole new licensing theme, if the board's like, we
Yeah, if
don't
there's
want to
no
do that.
appetite for it. Well, the other thing too is,
It's up to the board.
That's what I'm saying, have them look at it before we get too far.
yeah,
Because we're, this, I'm not saying it's major, but it's more than zoning we're talking about here.
The other thing too, you can remember from the previous meeting was that the idea of establishing a regulatory license was an option. And as the planning commission, we can decide not to recommend it either. I mean,
we
so,
definitely
I mean,
can.
if we look at it and say, for the one application we've had in 2 years, it's not like there's gonna be a flood of 50 a year for these licensing may or may not be needed, but, I mean, I like it, I think it's good.
I'm
but-
with you, and I think you're right, we kind of need to make the decision, I would say now. This is an option that was presented from our consultant that they recommend. And I think we need to either accept it or say, no, we don't like that option. I'm in favor of it. I think it gives us more protection and more ways to control a potential, application or special land use.
I like the approach as well.
But that is a good point. I mean, we were presented the options, and I feel like we're going down this path because this is the option, but if the majority of us didn't like it, maybe we
Well, I can
direction.
definitely communicate with Ross and then also talk with the supervisor and make sure that we don't invest any more time or money into this unless we have any kind of, unless we have some definitive direction as this is the way to go.
And this was our first step, is getting the draft for it.
Yes.
So now we can kind of decide which way we want to go. I think just, preliminary vote here, I think everyone's in favor of this option. Are we, or is anyone against it?
No, I guess.
Yeah, I think that's a good thing to do, get the board on board and then have attorney review.
Okay.
Now, as far as our schedule on this issue, the moratorium is expired in June. So That's also what we need to kind of think about with public hearing, county review, and then the board approval. So maybe we need to,
Yeah, we can definitely talk.
it might need to be extended, you know.
Right.
Yeah.
We'll talk to.
But I think we got another couple months before we need to basically let the board know we're not ready to adopt it in time and that they may want to extend it.
Yeah, I would think on that line, if we make the edits we talked about tonight, just to clean up these superficial things, and we could present this draft to the board, I can ask, for it to be on the agenda of an upcoming board meeting, and then at least float it by, the board members for some discussion and see if there's an appetite to want to pursue it, then better to do that sooner than later. They seem like they should go together, if we're gonna push the ordinance,
Yeah,
the zoning
I think,
ordinance
yeah.
and the regulatory together.
I think it's got to go all together.
Yeah, I think, that's kind of what I'm feeling, but I don't know.
So we're maybe a little bit behind our June schedule, but if we got to extend it, no problem. We've been making great progress on it, so. Anything else? Anything else from planning commissioners on this item? Hearing none, move on to new business. Item number 1, Ellsworth increase in accessory structure size. This is the one on Shannon Glen, 6-acre parcel. We discussed it in the public hearing.
Yeah, I know. The issue, my only thing is that if we approve it as 1,200, then it should.
Up to 1,200.
Up to 1,200, the plan should be corrected to state it as 1,200, right? But, because it shows a bigger barn, and obviously we'll have to go to the next.
We'll make the motion.
Yeah, that's on.
We'll make the, in a potential motion, we need to make sure to state, request up to 1,200.
Yeah, that's the only comment, John. I'm good with
I think that's the other one here. Yeah, 'cause even in the application, it says larger than the present 1,200 square feet allowance. So I talked to Carrie about this, and she was gonna have him revise it, but I said, well,
Didn't they mention they were gonna go back to the ZBA to
you know,
get larger?
that has been mentioned, but I think our position is, we're gonna, that's outside of our
You're right.
regulation. So I guess if there is a potential motion, just state, up to 1,200 square feet maximum.
Based on the criteria in the zoning ordinance, I make a motion to approve the application, provided it's only up to 1,200 square feet that we'd be approving.
So amended. Amended, yeah.
Yep.
Yeah.
So move, you support the motion.
I support, yeah, the amended,
Okay. All in favor signify by saying aye.
Aye.
Those opposed? That motion carries for approval. Move to next item, new business item number 2, Miller increase in accessory structure size.
Make a motion, we approve as submitted. Oh, unless there's discussion.
The only discussion I have is, I did like Zach's motion, if someone's gonna make a motion, based on the criteria in the zoning ordinance,
Yeah.
because in my opinion, we did, cover those things.
Yeah, I'll accept that amendment to the motion.
But
Or Kevin, go ahead.
no, I was just curious about just that driveway that accessory driveway, like, is that ever gonna be something that gets filled in? Is that,
Well, I mean, why would they fill it in? How are they gonna get their pontoon in there?
oh, okay, no, you said they were going this.
No, they're going here.
They're going that way.
They're going here. So
Right.
there's 54 feet between the next house, but they got 18 of it.
They got 18.
So, I mean, why would they ever want to fill it in and they can't actually support? They
Well, I
probably could.
didn't mean fill it. I thought they were gonna put a driveway there too.
No,
Okay.
they're just gonna use that, it's grass right now, I believe. They're just gonna use that to pull their pontoon boat back there,
Cut it.
probably twice, once a year in and out. And then the other units, I mean, I saw the side by side and,
Yeah.
I mean, that just drive through the grass or something.
It's pretty straightforward.
I think so.
And by the way, Robert's Rules of Order does allow us to have a motion and support and pause for discussion,
I
for more
kind of
discussions.
I cut Rich off like
No, that's
partway through his
perfect. No,
motion,
that's
so
fine, yeah,
I guess we'll just redo the motion if you don't mind.
Just so
But yeah,
you
you're
don't
right,
walk
and it
away
should.
from
It should be,
feeling like you have to.
We should have
everything
discussion.
done ahead.
I should offer up discussion after the motion and support. Usually, we've all discussed it, before then, but.
Sure.
Okay, so pursuant to the zoning ordinance, I make a motion that we approve the Miller increase in accessory structure size as presented.
Support.
We have a motion and a support. Any further discussion? All in favor signify by saying aye.
Aye.
Those opposed? Hearing none, that motion passes for approval of that. Moving on to the last call to the public for any items. Scott, go ahead.
Something I want to bring up to you guys, and bring up to the board. Helene and I were discussing this, and I had thought about this before, and she brought it up. Her and Ted were discussing it. Is any new applications that are coming in for anything? I'd like to see if, I don't know if Zach could answer that. If we could get it recorded in our website, when it first comes, when they come in to make the application, is there any way they can get it recorded into our website? Is there a page like we have for everything else? So when they come in, the public is notified as soon as they come in. As soon as they sign that paper and put it in, it's applied for. And we know it's there, way ahead of time. So people, neighbors and stuff like that get like a little bit head start, on what's going on in their neighborhood, stuff like that. I think you understand what I'm asking for.
Yeah,
What we're asking for.
I don't have any idea on the.
No, I didn't know if you could answer that. I don't know what the legalities are for that, but as soon as they make the application, it's
a public document.
public knowledge. So thank you guys.
I guess one comment on that, Scott, there's, like, say if we get an applicant, like for a planning commission item, we take that through a subcommittee first and kind of review it to make sure it's meeting the requirements and stuff like that. So then it'll come to the full PC. So
I know that.
I don't, and sometimes they don't get there. We're like,
Upcoming violation, 14-hour workday limit, 11-hour
it's
driving
not,
limit.
it's not ready, or they don't meet, maybe they applied for something that is not even gonna get approval because it doesn't even meet, so it might just be scratched,
Okay, so as soon as it's available.
I'm not saying that we do or don't, and with that, that's up to the township, I'm not saying township board, but the township
That's what I'm saying.
management. I mean, we don't control what goes on the website,
Just as soon as possible.
I don't disagree with your thought process on
I think
that.
we should know as soon as we can.
I tend to find myself digging through emails to find the latest site plan, right? But, I also don't wanna, cause any extra work in the township.
It's just something, if we could have someplace where it's posted.
I understand. Thanks for the comment. Any other comment? Jeanette?
Yeah, Jeanette Ropetta, Tyrone Township. John, I appreciate you answering his questions, and I wish that more meetings were like that, where you're able to have a little bit of back and forth, especially when it's something that's easy to answer like that. we keep saying the board, hearing the board saying that they're not allowed to answer, but I think that that just makes for good communication. Number one that I wanted to say, so McKenna, I think you, person representing McKenna said that they don't have any experience with the, well, I don't think you meant it that way, but with the marijuana ordinance, something that you said about not having maybe some knowledge about a certain aspect of it, which, I mean, nobody can know everything. But I'm just wondering again, why, and maybe you guys do, but why don't we look at surrounding townships ordinances and seeing what they do? Why aren't we looking to see how do they handle extra licensing? I mean, I would think that that would be, oh, maybe you want to say something?
Through the chair, if I
Yeah, go ahead, Mario.
we do, I've written multiple ordinances for multiple communities, and I have reviewed some of the adjacent communities' ordinances for different approaches.
Okay, good. So I was wondering, because there was so much talk about whether or not employees, et cetera, so I would think other ordinances in other communities would have that laid out, especially around us. Number three, I'm just wondering, you approved 2 items tonight, but isn't that supposed to be you're approving them for recommendation to go to the board?
Incorrect.
Or you guys actually approve them?
Incorrect.
I'm sorry?
Yeah, that's planning commission approval
Okay,
on those. That's the only item that I know of that's approval and not the board.
well, I learned something
It's
new
not
tonight.
approved recommendation.
I'm sorry, I'm talking to John.
It's okay.
I thought that, I just thought everything that you sent to the board, you
Yeah, it's
approved.
in
I'm sorry.
21G, modification of requirements. The planning commission may approve the following modifications for detached accessory structures or buildings
Okay,
located in the R1, R2, or LK districts. An increase up to 2 feet in height of detached accessory building, and increase in the permitted building floor area up to the maximum of 1,200 square feet.
okay, that's awesome. So why does it goes to the board just for a final?
It doesn't.
It
That's-
doesn't?
It's approved.
So it is approved tonight?
Yes.
Okay, great, thank you, my misunderstanding, and I appreciate you answering that. And I'll also just say that there was a code of conduct that was approved, or I don't think they approved it, but they talked about it, voted on it at the board level that affects all boards. So I find it very disrespectful when people up here are chatting and talking and laughing, especially when you've got people presenting. Review the tape. But I just think that there should be a little better decorum up there. And I'm not looking at you, John, I'm talking about other people on the board. Thanks.
Thanks for the comment. Any other public comment? Hearing none, we will move to miscellaneous business. Anything to discuss under miscellaneous business?
Do we have a plan for the workshop yet?
We haven't set an agenda,
Okay.
but I think, but Carrie has requested that we change the, we do have a special land use amendment coming up, and I believe it was decided that it was going to be a minor change. And Carrie wanted to know if, did you see the email,
Yeah.
Kevin?
Yep.
Bill, did you see the email?
Yeah.
Carrie wanted to know if we can convert the workshop meeting to a regular meeting,
Okay.
and I don't have a problem with that. The only thing is in my opinion, based on what I've seen in this revised special land use, I don't think it's going to be approved in the first meeting. I think there's going to be some
Subsequent.
some additional reviews and stuff.
Okay.
So I don't see a problem with handling it, but I think when we introduce a new item of business, it shouldn't be it's not a new item because it was old, but it will be under new business.
Okay.
I think it should be under a regular meeting,
Not a workshop.
probably. I don't know the legalities of that. So I think if everyone's okay with that, I think we would like to change the workshop to a regular meeting next week. Any heartburn over that from anyone?
I don't have any issues, the documents are ready, so we'll have them in time to look at.
Yeah, they,
That's the only
you know,
thing.
it
Sometimes
was-
it goes late.
This special land use amendment was, you know, they sent it over, and I had a lot of questions, and stuff, and they haven't filled that, they haven't, you know, answered the questions.
I think before I don't think that we should determine that there's a conversion here. I think we just need to wait closer to the time that we start receiving more of that information.
Well, I
No,
think
I-
now we gotta make a determination if we were gonna have I mean, it's next week.
Right, but before in the past, we've just.
Usually
made
Ross
conversion.
determines, yeah,
Right.
yeah. But as long as we, you know, people are indicating they're gonna be here, you know, since workshops are optional and the planning, and the other ones are.
Right.
So,
No, it's just the few in the past we've had it, and then you get the documents the day of or the night before. and
the
it's really
documents are
hard
ready.
to-
The documents
so
are ready.
That's all.
But
That's
it's,
yeah.
in my opinion, it's gonna have, there's gonna be comments and stuff. It's-
Yeah, okay.
But I believe the applicant is on a timeframe.
Okay.
And this is, this is the Foster storage.
Okay.
And we gotta make sure it's 6 o'clock, not 7, if we convert.
Yeah, I think
No
it's,
issues.
I think it's 6 o'clock, everyone good with 6?
Yeah.
So, we'll indicate that, to Ross. Any other miscellaneous business? Well, in addition to that, you know, I think the marijuana we're gonna discuss it every meeting. It'll be on the agenda. If we get an update by then, we'll review that. If not, we'll just discuss it and keep it on the agenda. Utility scale solar, I think that will be off the agenda because we're gonna move it to a public hearing. And so, that's what we have right now. Any other comments on that?
Sounds like that'll be enough for the agenda that night, so. we can
Yeah, I
leave it
think,
at that.
you know, that special land use, you know, it'll be new, maybe new to some, and, you know, it's got a lot of pages, I mean, so, we'll probably have, to me, it'll just be the introduction. I would like the planner's review, we haven't really discussed that with Ross. I think we've barely got over the decision if it's a minor or major change, so. So that's all I have for miscellaneous business. I guess we'll accept the motion to adjourn.
Move to adjourn.
Support.
Motion and support to adjourn. All in favor, signify by saying aye.
Aye.
Meeting adjourned.
That's true.
Someone came in and tried to get approval for like 40.
Congratulations.
That's $4.
What district?
That's a good question. I have to look at my map.
Yeah, oh, you're actually asking.
Yeah.
Oh. Is it the schedule of regulations?
You're welcome.
Thank you. Very good job, Andy.
I can't, it's in there. You have to read it, I forget.